Yes, it is possible. So I've represented um, the prospective purchasers, prospective lessees or tenants that are going to move into a property where there's board approval that's needed for occupancy, whether it's for a new purchase or whether it's for a lease. And I've also represented associations. So there's definitely been some adaptations at the community associations, whether those are homeowners association or condominium associations or cooperatives. So everybody's had to make some changes in regard to that, and associations have had issues, and they talked to me about the closings of certain common areas, the ability to actually produce records on time, which is via statute, and the approval process, but they are granting those, and I have yet to have anyone denied possession unless they would have been denied otherwise. So it hasn't been something where I've run into associations that have said, we're just not doing anymore. And in fact, if I had associations that were to say that either to me and I'm counseling them, or I'm on the other side counseling a member against an association, I certainly think it would be brought to their attention that you can't just flat out ban or just stop the approval process. You may have to have different ways. You can have voting via unanimous consent by boards. You could also too have the board appoint a particular liaison to approve, unless that is prohibited by the governing documents, which most of the time it's not, and select a liaison that could approve or disapprove either leases or occupancy with a new seller if that's required. So there may be some delays, but I haven't really seen that, whereas to the extent, I should say, to the extent where somebody is not taking possession where they would have before because the association is just going too slow on the approval process.